to call this meeting to order for the regulation and taxing the cultivation, manufacture, and commercial sale of marijuana in Anchorage for March 10th, 2016. We'll begin by going around with identifying individuals here at the table. With you, our illustrious attorney.
Julia Tucker, Assembly Counsel.
Pete Peterson, Assembly. Dick Drainage, Assembly.
Bernie Hall, Assembly.
Bruce Schulte, over.
Erica McConnell, Office of Economic and Community Development.
Bill Falsey, Municipal Attorney.
Barbara Jones, Municipal Clerk.
Thank you for being here. Appreciate it. I'm going to begin as my typical with individual reports from us, and then we'll handle our one topic of the day, and that's on-site consumption that Erica and Bill, working jointly, I should say, are doing a great job. We're not done. It would appear we've got a bit of a way to go, so we'll get there. The chair's report basically is really quick. We're pretty much right on schedule. We're cleaning up a couple of things, and i.e. one of those is the on-site consumption. And part of what's been kind of delaying us on that is we've been following the lead of the Marijuana Control Board, and Mr. Schulte is going to give us a briefing on that here a little later in the meeting. But to this point in time, they haven't done anything with on-site consumption yet. And there's a House Bill 75 dealing with some marijuana issues that have been referred to them through the control board, and Bruce will kind of give you an update on what's going on in regards to that. So, and actually, you're the next person on the agenda now that I look closely. So, Bruce,
Okay.
go ahead and share with us kind of where you are.
Okay, so see, I guess I'll start with the schedule. So on February 24th, the state began accepting applications for licenses. I believe in that first week there was about 100 applications received. Some of them were incomplete. I think the staff is working on folks to iron through those. I think at this point there's a little over 100, but I don't know the exact number, and I don't know the distribution of applications, how many are cultivators versus retail stores and so forth. A bunch of them have been running ads in the paper. That's a requisite public notice period, and when that public notice period is complete, then the applications are considered complete, and that starts the 90-day window within which the state has to respond to their application. So what we're looking at right now is a board meeting on June 9th, I believe, and the expectation at this point is that we'll be approving some number of licenses, starting with testing labs and then cultivators. There's several testing labs right here in Anchorage, right? I know we're applying, and then cultivation will follow. And the strategy is to defer retail store licenses to our September meeting. And then the rationale there is because it is an agricultural product, and because one of the provisions of licensing is that one must be selling legally grown and taxed products, there's really no way you could issue all the licenses on the same day and avoid a complete train wreck. So the idea is we're going to get cultivators going beginning of June. That'll give them 90 days to grow, dry, cure, and process some products. And then in our September meeting, we'll issue licenses for retail stores. So really, realistically, the earliest possible date we're going to see a licensed retail store will be sometime in September.
Out of curiosity for my own edification on this, the way that the initiative read created a statute stated that you had to process applications within 90 days of receiving them. Are you covered okay then where you're saying we're actually, some of these aren't going to be processed until later, so that there's not going to be an issue for the state?
It's a really good question, and the Assistant Attorney General that advises the board weighed in on that. And the idea, the conclusion was, one of the provisions of these various licenses is that, well, the retail license in particular, is that you have to be selling lawfully grown and or processed products. There's no conceivable way they can do that until a certain period of time has elapsed. Now, you could discuss what is the appropriate period of time for 45 days, is it 60, is it 90 days, depending on the strain and the product, that could vary, but where they came down on that was since they cannot lawfully meet the terms of their license, we're on solid ground not issuing the license until a point where we think they can meet the terms of the license. Does that make sense?
The logic makes total sense. I would assume that if I were going to be a retailer, I would say I probably got 6 to 8 months just being able to get a site ready to do a retail sale
Yeah.
in. And if you delay me getting that license, then it throws me further down in regards to pulling permits, construction, et cetera, so forth. But I understand the logic. I appreciate it.
It's a valid point, and some people express concern about this staggered schedule. Well, Washington, by the way, issued all the licenses roughly at the same time. It turned out to be an awful mistake, because they had retail stores with nothing to sell, and they were just sitting there paying rent and utilities and payroll for 2 to 3 months, and a lot of them caved before they actually had product to sell. Some people I've talked to here have actually said that it's a bit of a relief for them, because it gave them an extra 3 months
Sure.
to find property and get the lease locked up and then get their application in. So folks that are gonna both grow and do retail, some of them that I've talked to are seeing this as actually a bit of a benefit, because it allows them to stagger their 2 businesses, they're 90 days apart.
Very good.
So now, on the issue of on-site consumption, we were expecting to see, that's really the one component of the regulations that it's not yet complete. There's a placeholder in there that says that an on-site consumption endorsement could be available for retail stores if they apply for that. What was left open was the parameters, the specifications that they had to meet to qualify for that endorsement. We were expecting to see some draft language for that at our February meeting. It wasn't ready by then. There was a pretty extensive conversation amongst the board at that February meeting as to kind of the expectation of what that on-site consumption should look like. I don't know exactly where it's going to end up, obviously, but I can say that the general tone of the conversation was that we need to be pretty conservative about it. I personally floated the idea that we have to have limits on the types of products that are sold there and the potency of those products. And the idea there is just to avoid backlash from the legislature and from others who are, frankly, nervous about that one thing. In particular, they're concerned about people driving under the influence or being impaired in public. And those are legitimate concerns that hopefully we'll address in the regs. At this point, we're expecting to see some draft language at our meeting in April, and if everything works out, I would hope that we'll put that language out for public comment after that meeting, and maybe even adopt those final provisions at our June meeting. So then, by June, hopefully, folks that want to have a retail store with the on-site consumption endorsement will know what that target looks like that they have to hit.
Makes sense. Any questions for Bruce?
I've got a question for Bill when we get over there.
Okay. Anything else, Bruce?
I think that's it.
Thank you. About the police department, we have no representatives from there. The legal department, you're gonna be the stars this evening, unless you have something else you wanna share with us.
We can give you a brief update on things which are not related to on-site consumption, which is, as Bruce mentioned, the application period opened February 24th. We have designed the municipal process to begin after the application was complete at the state level, so we have received no applications at the municipal level because there are no complete applications at the state level yet. In the state process, we are to receive a preview copy under the state regs. And my understanding is that we have now seen something on the order of 8 to 10 come in. We're not processing them yet because they're not really complete. We are starting to see some in the newspaper, and we've seen a few of those for Anchorage. Substantive issue, one of the process issue is that we do have the municipal application largely complete now. The form ends up being 3 or 4 pages, and I think by design it was combined license, land use application. It's pretty simple, it's pretty straightforward, and it ends with an attach everything we sent us to the state. So we try to make it as non-onerous as possible, and I think we have achieved that goal. Other substantive items which were not related to on-site consumption, the Assembly is aware that there is still a question of whether there should be a marijuana neighborhood responsibility plan. That is up in the air as anticipated in the licensing ordinance that we passed, but the details are now being worked out in committee. And I'll say we've been starting to get some inquiries about how exactly the shortest practical pedestrian route should be calculated. It's becoming clear to us that we're gonna have some rules so that we provide some consistent answers about that. We also reached out to Cindy Franklin, and it sounds like even though that has been the standard for alcohol, there aren't really hard and fast rules at the state level on alcohol. They've largely deferred to the municipalities as to how those routes should be measured. So they're not gonna solve that problem for us, that's the problem we're gonna have to solve. So more will be coming to you on that, but I don't think what we're gonna propose will be particularly controversial. Oh, and the last thing I will mention is that there is a interstate coordination group that has arisen. Erica and I were on a phone call today with Oregon, Colorado, Washington. It sounds like we are now joining the conversation in a more full way. They too are now looking very seriously at all of these on-site consumption of marijuana club issues. So we'll all be moving in the same direction. And suffice to say that we're going to be in communication and looking at what they do as well.
Great. Thank you. Really got a question for you. I had a chiropractor call me today. And yesterday when he was in business, a lady walked in and now she's planning on opening a marijuana business right next to it. And he says, my clients that were there threatened never come back again. So the question I have for you is, can a landlord decide he does not want to rent space to a marijuana store and not be accused of discrimination?
Well, I guess I'm not prepared to give you an official answer, but my initial take was that yes, that the landlord, as long as you're not discriminating on an invidious or a prescribed grounds, could decide whether I want a cafeteria or a comic book store or a marijuana establishment. And I don't know there would be any reason why the landlord wouldn't be within.
Would you look into that for me so I can at least tell him an answer that has some legal validity to it?
Sure.
Because he says, I've got kids coming in here for chiropractic treatment, and my concern is I don't want it anywhere near me. Because I was down in Oregon, I guess it was, you could smell it everywhere. So he's just concerned. And we're gonna get a lot more calls like that as we move into the phase of becoming legal here.
Sounds like Julia may have something to add on that conversation, but given that it remains illegal under federal law, I would think they probably have ample grounds to treat them differently, but anyway.
I was thinking about that, but I was also thinking that in our code, we have the provision that the property owner can put in the lease that there is no consumption. That's not gonna help though for the establishments that are not gonna have consumption on the premises. So in the same way that that provision added something that I would have thought would have been inherent in landlord-tenant law anyway, to make it explicit, maybe we should also look at making something explicit. And maybe you could help in saying whether that was, after you look at that, whether that was an appropriate, because I'm thinking that I'm gonna be asked to do that probably, and
You are.
we might as well.
It's just a tip of the iceberg, so Bill, I appreciate anything you've got on it. Because like I said, the first call we got was today. I just been a lot more. Thank you.
Let the records reflect that we've been joined by Todd Sherwood from the legal department. Yeah, Pete?
Thank you, Mr. Chairman, and this actually doesn't relate to what we've been talking about so far, but I had a community council meeting last night and had someone come up to me from the community council and wondered who at the muni was the point of contact for them to call, because they had been approached by a couple of marijuana entrepreneurs about opening marijuana businesses in their community council area. So who is the muni person that should be the contact, the go-to person at the muni?
Well, that's a good question. Out of the Office of Economic and Community Development, I'm kind of set up as the overarching person to try to coordinate everything. But I'm also sending, when someone has I want to put a business at this location, and am I far enough away from that school? Those kinds of questions are going to the planning department, because the planners have the resources at the office to do the kind of the mapping and looking at that sort of thing. So, they can certainly call me, and if it's appropriate for me to refer them to planning, I will do that. But they can also start at planning. And I have plans to, develop a website that'll compile all of the various resources of the municipalities related to marijuana into one place. These things are coming.
Perfect. Anything else?
Thank you.
We have no one from the finance department, planning department.
Sorry, stepping back to the issue of landlords and tenants, the application for the license and special land use permit does require the property owner's signature. So I don't know what that means from a legal term about whether that could be challenged, but that is a municipal requirement that the property owner give permission for the entitlement request that is happening on the property, even if the property owner is not the licensee.
Ernie, can I just follow
Yes,
up?
Julie.
Is that application requirement reflected any place in the code?
Not in the marijuana land use ordinance. I would
Was
have
that
to
in the
go back and,
licensing?
not specifically, no, I'd have to go back and look at the other parts of code. But it's been standard, at least for alcohol, special land use permits to require, property owner's signature.
So I'm just thinking out loud here, we've had a couple of instances where policies have been challenged because they're not in code. And so maybe we can incorporate that in the umbrella of looking at this, just to make sure that that's not subject to being challenged down the line.
Thank you. Madam Clerk?
No report.
No report. Okay, Erica, Bill, let's
Hey.
discuss the on-site consumption.
So, I first want to clarify that there's kind of two paths forward for allowing social group consumption of marijuana in a public place. And the municipality can choose one or both or neither. So I would distinguish them by calling one of them on-site consumption, which would be on the site of the retail store, consumption on the retail site, and I would call the other one a marijuana club, which would be something entirely distinct from one of the 4 licensed premises that the state and the city have established. So today, what I'm going to propose to you is regulations surrounding marijuana clubs. I don't think, or it would be our advice that the city would not want to move forward with the on-site consumption, consideration of that sort of path until we see what comes out of the marijuana control board at the state level.
Makes sense.
So, that said, there are, pros and cons to both of these paths. One of the, pros of going with marijuana clubs, so the idea of a marijuana club is that, they would be a membership situation, so they're kind of not entirely public, but sort of quasi-public. But there would be provisions for temporary or guest memberships so that you could have tourists coming for a temporary period of time. The members would bring their own product to the club to consume, so there would be no
sales in the club.
sales, there would be no marijuana provided at all by the club. There are some models that I've seen where the club may provide paraphernalia, and so that's something to discuss, but the club would not provide any marijuana. All marijuana product would be brought by the members. And as I propose it here, these clubs would be licensed and permitted in the same way that we're proposing, or that we are now going to be licensing and permitting stores, cultivation, of other types. So the things that are kind of useful about going the club route that you would encounter that could be negative about the retail store on-site consumption strategy is this issue of over-serving, over-consumption, liability of the store owner, and how do you address those issues. So with a club where there is no serving, and people are only allowed to bring a certain amount, they're only allowed to carry a certain amount with them, you avoid liability of the owner and, that situation of over-serving. But you also then create the potential for peer-to-peer sales at the club. Oh, I have a little extra I'm not gonna consume right now, do you wanna buy it from me, sort of thing, which you presumably would avoid at a retail store. I'm not sure we need to talk more about that now, but those are just things to kind of keep in the back of your mind.
Yeah, Judy, go ahead.
But it would be legal for someone to give someone some of their own product. Okay, just wanted to clarify.
So the proposed definition would be, and this would exist in Title 21, would be an establishment where members gather to consume marijuana in a social setting and to which membership is required. What's proposed is that a club would be authorized to maintain a place where marijuana or marijuana products are brought, bartered, or traded by club members for on-site consumption, could sell or provide food and or non-alcoholic beverages, and could provide entertainment that is not considered adult entertainment. What a marijuana club could not do would be to sell, give, distribute, barter, trade, provide marijuana or marijuana products. Could not allow any person on the premises who is under the age of 21, could not store, stockpile, maintain, or keep marijuana on the premises, and could not sell, provide, etc., any alcoholic beverages. The issue, a major issue is how do we deal with the secondhand smoke ordinance? So what I proposed.
16?
Yes, Title 16, Section 1665. And so what I proposed is just in Section 030, which is a list of exemptions, area where smoking is not prohibited, is that one would add marijuana clubs with a valid municipal marijuana license and special land use permit. And that would just be exempt, just take it right out of what the secondhand smoke ordinance covers. Granted, these clubs are probably going to have employees, and so in some ways you're going against the spirit of that, of the secondhand smoke ordinance, but I'm not sure I see a way around it. And one could assume that the people who might choose to seek employment at a marijuana club are gonna be happy to be in an atmosphere where there's marijuana smoke.
Well, if they aren't happy to show up, they will be by the time they leave.
Like I said, for a while, there will be.
So turning to the second page of the handout, so like I said earlier, the assumptions that they would require both a license and a special land use permit that would be approved by the assembly in the same manner and process that these other districts are going to be applying for licenses and land use permits. And so some of the questions would be about what sort of standards we would want to require clubs to comply with. So some of the questions relating to the applicants are, would we want to have the same restrictions for owners of marijuana clubs that, with regard to criminal history, that we have to for other types of establishments? If we do, so first of all, remember that the owners of the clubs are not going to have marijuana passing, or not intended to have marijuana passing through their hands. The club is not providing marijuana, the club is not keeping marijuana on site. If we say, yes, they do have the same restrictions with regard to criminal history, then the MOA is going to have to step up with, verifying that they do meet the standards, background check issues, and I'm not really the best person to speak on those.
That's the problem that the Marijuana Control Board itself is still trying to work through with the state legislature. There's a state statute that governs who can get access to the National Criminal History Database. We can't, Marijuana Control Board can't, but they're asking the legislature for permission to do that, and we thought that was going to go through in short order, and it's got a little gummed up with some other things. We would be in a position where we can do it inside of Alaska, but not nationally. Maybe it doesn't matter as much, because like Eric is saying, the club is the proprietor of the place, but not a marijuana handler.
So that's a question. And then similarly, would we have the same restrictions with regard to Alaska residency? Moving on to the license, would the assembly want to have the same restrictions regarding transferability? If I own a club and I wanna sell it to my friend Bruce, can I just sell the license along with, the club, or would we have the exact same standards about, no, the license isn't transferable, and if I can sell him my lease and my sofas and things like that, but he would have to come back to the assembly and get a new license and a new land use permit. So that's the question. The next question.
I'm sorry, technically, he has to have a state license as well.
No.
No? Oh,
Because
right,
not
right,
for-
okay.
not for clubs.
Okay, I'm good, I'm with you now.
Yeah. So this next question, I'm hoping Bruce may be able to shed some light on this. The question would be, would the club owner and employees have to have a marijuana handler permit? On the one hand, they're not handling marijuana, but on the other hand, the TAM cards for alcohol servers, they're taught to recognize signs of impairment and that sort of thing, and I don't know whether the marijuana handler permit training will address those issues, and so whether it would be in the interest of the community to have the employees of the club be able to recognize signs of impairment and step in if, maybe somebody shouldn't be driving or, that sort of thing. So I don't know if that.
Yeah, that recognizing that somebody is impaired, whether by cannabis or other things, is one of the components of the training for the marijuana handler part. So, I think that would cover that case.
So, one could require employees of clubs to get a marijuana handler permit for that reason, even though they're not actually going to be handling marijuana. Other requirements of other types of establishments, we have security systems and locking, standards for locks, as there won't be any marijuana on site. Are those necessary? I separated out video surveillance because maybe one can make an argument that might be a little bit more necessary than the security system and the locks, just to, capture whether there's any, issues going on at the club. Waste disposal is another question that we kind of weren't quite sure of and needed to probably check in with people in the industry or our existing club or maybe Mr. Lofty who's been to that club who, may have a sense of whether there could be waste left over from the product that the people are bringing to the club. So that's kind of the question. I've seen a couple of other proposals that restrict serving food that's prepared on site, so that all food would have to be, packaged. And I haven't really figured out kind of why you couldn't have food prepared on site with the proper health department permits and that sort of thing. But that's a question. And then, under the licensing section, the last thing would be, an application fee and a yearly license fee since there's no state license, there's no money coming from the state for this type of, establishment.
Question? I do on the food, that's an interesting one. It seems to me the only way you could do it in a social club would be if you provided a kitchen and they brought their own product and prepared it on site.
I'm not talking about, marijuana infused food, regular food.
Regular food.
Yeah, hamburgers, whatever.
Not just Cheetos.
Right.
More of an observation on that subject. At one point, the state regs prohibited selling in retail store any food that required refrigeration. And the theory was that if the food went bad and made somebody ill, it'd be hard to tell if they were ill because of bad food or because of cannabis in it. That provision was changed. So retail stores will be able to sell infused products, even if they do require refrigeration. They do have to have a food handler's card and training to go with it. So if you were sort of extrapolating from there, even non-infused products, if they're handled properly, and I agree, a food handler's card permit would probably be an essential component of that. I'm not sure if there's any public health or public safety issue there. That could be addressed through mechanisms that already exist.
And I'll say some of the genesis of these questions was reflexively, the first thing we thought was maybe we could just dump this into 1080 and make it a new license type. That made us go through it and say whether all the requirements that apply to the other bona fide real estate marijuana licenses make sense in this setting. And part of the reason we pulled these out is because we have some doubts about that. And for instance, the video surveillance, I think the state regs require you to keep 24-hour video surveillance of specific access points, and I think you're supposed to keep it for something like 40 days worth of video surveillance. But here, the only time marijuana is on site is when people are actively there, and then at the end of the day, everybody goes home, there's not supposed to be any marijuana. So why does this establishment cry out for more particularized video surveillance as opposed to a pub or convenience store? So that's why we're going through this exercise.
They're really good questions.
So, moving on to the kind of. Oh.
Two questions.
I bet we're gonna ask the same question.
Well, actually, mine's a comment because I just thought now about the security thing, because we all think that's a valid point, you know, is it really needed? My only concern was that, I hate to say youth of our community, but they found in Colorado, for example, that the lots were always being cut off at dumpsters, even though they shred this stuff and mix it with stuff because they think maybe there's something there. Maybe one thing we could have as a requirement is signs be posted that say no marijuana kept on site. And that might keep out sort of the nuisance burglaries that think there's something there. You know, just like, yeah, the signs that say Caddy has no more than $20 changed any given time, but maybe that's a in between.
Well, Todd, I thought you were gonna ask the question when Bill said that, when everybody goes home, there's no requirement to have the video cameras, and then my question is, are there gonna be any required hours for operation, or can it operate 24/7?
So the special line.
Got it, thank you.
Sure.
I have one other question, just out of an abundance of caution, to follow on about the security. From time to time, when there are social events here, youth or not, alcohol or not, there have been, you know, boxing, wrestling, there have been requirements that clubs have security on site. Is that a consideration here? Because what I'm seeing is that there are things here that really don't apply to non-commercial marijuana establishments, and that's what a club is. But there could be some other things that might, you know, also apply that might not apply in other places, just based on experience with the city and other situations.
So you mean you're suggesting that your requirement for a security guard?
Yeah,
Yeah.
on-site security be provided in a club. I mean, I don't know. I'm just saying that there's gonna be some issues like that, and that was one of the ones where, about security that came to mind.
Yeah, just a couple of thoughts on both the security cameras and security guard. I think what an important consideration there would be, you know, whereas if you're in an establishment that serves alcohol, that's a substance that's known to promote boisterous, some kind of violent behavior, whereas cannabis is not. We actually have the advantage of having a club here in town that's been in operation for almost a year, and as far as I know, APD has never been called there. Now they may decide that they want a security guard, and this doesn't matter, you know, of course, doing business, but in terms of public welfare consideration, it's probably not analogous to a bar or, but it is serving alcohol because of that difference in compounds. The other thing I was going to suggest or offer in terms of video surveillance, at the state level, the requirement for video surveillance is really based on the imperative to avoid diversion of marijuana, either bringing black market marijuana into a facility and injecting it into a legitimate stream, or taking it off premises where, you know, without paying taxes and so forth. So if you remove those two factors, then it's really just a matter of protecting the safety of the individuals on the property and the value of the property, which I think it's a different bar. It's a lower bar because it doesn't really speak to public safety necessarily, it's just the integrity of the business. So I'm not sure that I have a specific recommendation there other than I think that if you were requiring video surveillance, probably would have a different standard in this case than it would one license was now.
Thanks, Mr. Chairman. And from what I was told and from what I saw when I took a tour of the club over here, and they showed me the rules that everybody has to read and sign and agree to before you can become a member. If anyone breaks one of those rules that they signed to agree to, then their security asks them to leave. And then they forfeit their membership fee and they're 86. So, I mean, I haven't talked to them to see if they've had a lot of problems, but that's what they were intending, how they were intending to handle security.
I have one more follow-up question, if I could. Is there conceived to be a requirement that the marijuana club is required to have a fixed location? Or can there be a club and it roves?
It would have to be in a fixed location.
And that's in a requirement. So I couldn't have a club and decide that my club is gonna apply to meet at the Denina.
You would need a new license and a new land use permit for each location.
$1,700 for land use permit.
Or your club could meet but not have any marijuana at all anymore.
Yeah.
But they could see a movie
Yeah,
together
they
or
could see a movie,
something.
yeah. Okay.
Julie, your hockey team could do that.
Yeah,
You know?
we lost him.
Let's cover land use.
Okay, land use. So, the thing that I don't know how, but I forgot to put in here is what zoning districts would these be allowed in? So that's a question, that I missed on my list. But then moving on to the list, separation distances, because we are not starting from a state requirement, we have a lot more flexibility to decide what we think is appropriate, always factoring in what we think about how we want to address the federal drug-free zones. So would we want to maintain the separation distances that are set up for the other establishments, or would we want to do something different? Another issue to consider in this situation is I think there are studies that show that mixing marijuana and alcohol consumption, that those two things are not a good mix. And so would we want to require some sort of separation from bars so that you don't have somebody going from the bar to the marijuana club and back to the bar and becoming impaired in that sense. And in order to be more, to fully kind of address the issue, the potential for overconsumption, would you want to require a separation distance from retail stores? So that you can't have the retail store and the club right next to each other, and you just kind of run over to the retail store and buy more and go to the club and kind of go back and forth. So those are things to consider.
And if we could, on that, just another awareness thing, one of the things we learned in Colorado, because they have a strict no marijuana in bars policy. The workaround for that, which at least at that time was allowed, is like a limousine service, party bus, and they'll pick people up in front of the bar and they can get as high as they want on marijuana while it drives around the block a few times and dump them off in the bar again. So that may be something to consider depending on to what degree we want to regulate and restrict the mixture of the two substances.
Here's where we would address hours of operation, whether or not there could be an outdoor area. If there could be, it would have to be shielded from public view with fencing. But the ventilation issue gets a little more complicated.
Worried
with an
about the
outdoor
smoke.
area. Yeah.
Smell.
So it might be something that you could do in some locations and not in others based on how the outdoor area, how close it was to, public spaces, that sort of thing. And then I did discuss ventilation because we are definitely talking about smoke. I did discuss it with Development Services, and they did tell me that there is a smoking club air exchange requirement in the building code, which I believe is the 60 cubic feet per minute per person. And then but the Title 23 doesn't discuss odor. So then we they together worked on the rest of this language, which talks about having the exhaust, either being treated, so pass through some sort of filtration system, or, having the exhaust discharge located in a location that's approved by the building official so that the odor is not detectable by other tenants in the building or outside of the building at the ground level. So if you somehow had your ventilation going up through the roof, maybe it was gonna be fine, but then it would be up to the building official, to make a determination. And then, even if the building official said okay, but later on there was, valid odor issue, then they would probably have to go back and deal with, treating the air.
Questions? Yeah, go ahead.
Well, I was just gonna offer an observation, I'm just put on my architect hat here for a moment. One potential, consideration, I think, is ventilation, and I mean, obviously ventilation is an issue, it has to be adequately addressed, but if we're requiring copious amounts of air to be exhausted outside the building, then it also means they've got to heat a equal amount of incoming air. So we could be imposing a tremendous heat load requirement on businesses where another way of handling the air might be more adequate. That's all I'm getting at. Because it's simply taking the air and exhausting it out of the building is, the air that you pay to heat could be an issue in the wintertime. In the summer, probably would be great. But there might be another way of addressing that where there's some combination of mixing of the air changes and filtration might be a more appropriate requirement.
Thanks, Mr. Chairman, and I'm not sure exactly how an ionizer works, but I've heard that they have the capability to take all odor out of air if you get the right one. And originally, when the club opened downtown, they had problems with the people in the building smelling stuff from the club, and they went and got a bigger or newer ionizer, and haven't had any trouble since then. And so there are, machines that have capabilities of doing that. You just have to get the right one,
I think some of us have probably seen the HEPA-style air filters that filter particulates out of the air. I went and bought an air filter for my home that's like that, but it also has a charcoal filter and something, I think it's got like cadmium or something built, in addition. I think it's incredibly effective at filtering odor. I got it with cigarette smoke, and it's very effective, rather expensive, but such a technology exists to filter that air and process it within the confines of the space. So, just there's a mechanical solution or technological solution that might be applied.
I guess the thought that's running through my head is on several occasions you've stated the fact that we've got the ability to determine however we want to handle this because there is no state requirement. We're kind of creating here. I'm wondering if we're getting out ahead of ourselves a bit here because it appears the state is going to do something. Whether
I can address that. So, at our July meeting, one of the things we wanted from the legislature was authorization to deal with marijuana clubs. And it was the advice of legal counsel that since clubs were not mentioned in the initiative, we had neither the right to regulate them or ban them. And so that's kind of where we ended up on November 20th. But the request for the legislature is still out there. As far as I know, it hasn't been addressed and may not be during the session.
Well, we can do it and always have to come into compliance under state if it comes in. I mean, we can be more stringent and not less. I don't think there's anything at all wrong with doing the work we're doing because we may be the model the state adopts if we get done here. So, but I just think we need to understand that that's something that's there is
you know, we have no state requirement now, so we've got a blank book, but depending on what the station decides to do. But I have no doubt that if we get out in front of this, they'll probably take a real hard look at what we already have.
Well, Fairbanks has the same, they're wrestling with the same issue.
Yeah.
And, there may actually be provisions in the initiative that authorize exactly this kind of thing. It says that in the absence of the state licensing regime, it falls to the local government to do so. So, I mean, I'm not a legal expert here, but it might well be that in the absence of state regs on marijuana clubs, this is exactly the right way for the municipality to deal with it for the moment.
Yeah, I agree with that. I mean, the initiative gives us pretty broad authority to regulate the time-based manner of the marijuana consumption. The one place where we could get high standard here is that the initiative prohibits public consumption. We would, as part of our tinkering here, define this kind of consumption to be non-public. And as opposed to a very hostile statewide administration of marijuana control board, they could say, no, that is public because it is not fully confined to your home, et cetera. And then, but I don't think that is a highly probable scenario. So,
Bill, do you think we can hang our hat on the fact that it's a membership only?
Yeah.
Not for everybody coming by, but it's a membership.
I do.
Okay, thank you.
This is incredibly good work. What do you need from us? Questions answered?
Yeah, and if you're
All
not.
the substantive decisions and directions.
I mean, if you're not prepared to do that now because we've just put this in front of you, you know, we can certainly, bring forward some draft this up. Like I said, you know, I had the framework of an ordinance which had the licensing within 1080, and for the reasons Bill talked about, we're gonna pull it out and put it into 1090. So I can finish that work and we can provide you with recommendations, and then we can make a decision.
Let's do that.
Okay.
I think that's absolutely the direction we go. We need to do that. Excellent. Any other questions? Great presentation, Barbara.
May I suggest, that you come back in 2 weeks? Would you like to do that, so that you could take a look at a draft in 2 weeks?
Oh, yeah, we'll go ahead and schedule a
Okay.
meeting 2 weeks out.
I just wanted to make sure that that was on the record before we adjourned.
No, that'll be fine. Yes.
Code enforcement. From your perspective, we need to enhance our assets in code enforcement. Because with this and other things, how many people do we have there now in code enforcement? 3?
I think there are either 5 or 6 officers, and my last conversation with Ms. Frost, it was very clear that particularly if we want to schedule regular inspections of these facilities, he was very clear that he needs additional resources.
Okay. I think we ought to invite Mr. Frost to come and join us at our next meeting, just so he's up to date on what we're talking about. Because he's gonna be, who's going to have to enforce that. I have no faith at all in the state enforcing it. No, sure. They don't have the money.
That's a different group.
They don't have the money. So it's our code enforcement people that have to be on the ground doing this. So we should be got the assets put in place.
That question also gives me total license to ask whether I have ever previously asked in this setting, or ever previously mentioned the existence of the nasal ranger.
Yes, you did, and I was wondering,
I want a nasal.
are we gonna use a human to measure odor? Are we gonna put it in here? It has to be an electronic device, because you did mention.
Well, the nasal ranger is not an
odor
electronic
ranger.
device, but I will say, sort of looking back to this question about air exchanges, I mean, I'll say my personal predilection is that generally we want to regulate to a standard. We want you to meet the desired future condition, and we don't care how you get there. And if you can get there more cheaply than doing an air exchange, then that would be fine. But the nasal ranger would be the thing that says, can I smell this from where I'm standing or not? Anyway, we'll figure it out.
What is the cost on one of those?
I don't know.
machines?
I feel like we looked, but I can't remember what it is.
If somebody gets a chance, let's look and see what the cost is.
Just Google nasal ranger, it's out there, it's pretty comical to look at.
But you know, people smell different things differently.
And it's
I would like a
important,
machine
it's in,
that does it to a standard we can identify.
I guess Seneca is gone, but as she can tell, there's a number of cases that have gone up to the Criminal Court of Appeals and Supreme Court relative to marijuana cases and the human's ability to smell marijuana to support probable cause, and is the weather cold, is the weather hot, and there's all these things, so the closer we can get to something more definitive, with the nasal ranger, the
It
better off
sounds-
we'll be.
Sounds like we're creating a new occupation for people with a good sense of smell. You know, what do you wanna do when you grow up? I wanna be a nasal ranger.
We get away batteries from that.
Public comment. Anyone, any questions? Yes, sir.
I would like you to at least consider different levels of consumption. You know, if you had, like certain bars, beer and wine versus hard liquor. So you won't have as many smoke issues with maybe just vaping or consumables versus a social setting or a club or a consumption where there's no joints, no bud, no true smoking going on.
Good observation. Thank you. Anyone else? Okay, if not, yes, Pete.
One thing we didn't talk about, was what about setting up a separate smoking room where only, in one of these clubs, where only the people who were gonna consume would go into that room? That way it wouldn't affect the employees, because they wouldn't be going in there.
I think you're always gonna need employees going into any space in the place, because there'll be some monitoring of activity and then cleaning and potentially serving food and things like that. But some club, I think, may wanna operate along that model as offering a space for people who don't want us to breathe in the smoke, but may wanna consume the way that gentleman was suggesting, so that's something to think about.
Yeah, because they could put some sort of air exchanger or ionizer in that particular room, and if it was a limited area, they might be able to clean that air up relatively quickly.
Anything else?
Sorry, can you open it back up to public comment?
Sure.
Thank you, Rudy. Yeah, a couple things. With regard to allowing outdoor consumption at a club, I mean, I personally would be completely opposed to that. I think trying to control odor would be very, very difficult. And when, the comment was made, well, it might depend on where it's located. We're talking about an urban municipal area. And with an Anchorage Bowl, I don't think you're gonna find a good site where that odor is not going to drift in and make, offend, someone nearby. So I mean, I think you shouldn't even go there. And I just think, I hope that all of you are really careful with this. Putting an exemption into the no smoking ordinance is real tricky. And a lot of people worked really hard to get that ordinance passed. And I'm afraid this would open the door for the tobacco industry to come back in and say, if you're gonna allow smoking of marijuana inside of a, public place, then I don't care if you call it membership only. I think these have to be viewed as something other than a personal home. And the intent was to not allow any smoking of the tobacco product in any kind of public area. And then yet you're gonna exempt a club from this. The tobacco industry is gonna be all over this and probably take you to court. Because if you're gonna allow an exemption for that industry, then we're gonna walk back in and try and get you to just toss that whole ordinance and pass back in 2006 or 7, whatever year it was. So I just think you need to be really careful with this one.
Julia, you had a comment?
I did, and it occurred to me before when we were talking about outdoor consumption, and perhaps it relates to the public comment that we get, that somehow when we're thinking about outdoor consumption, at least I am, I'm thinking about the odor and smoking outdoors, because that's it, but it seems to me that there could be a model where smoke marijuana products are consumed out of doors, and they wouldn't present the odor situation. So I think that we just have to keep that in mind on that ban. Because if you're gonna base a ban on outdoor consumption being that's odor and that it's being vaped or eaten, then you don't have that.
Sure. Anyone else? We're adjourned.